Hi, I'm Charlene Laney, co-founder of Newmaker Financial and Certified Financial Planner Professional. Today we'll be talking about the 5 key estate documents that we recommend you consider for your estate planning documents. Now, it's going to be in this order. First off is going to be your Durable Power of Attorney, also known as DPOA. Advanced Medical Directives is number 2. Your will is number 3. And number 4 is your letter of instruction, finally with your living trust as the final consideration for number 5. So let's get into it. Number 1 with your durable power of attorney. This is not intended to be confused with an institutional power of attorney, such as, if you have investments somewhere or monies at a bank and you do specifically that bank or that brokerage firm's paperwork in order to establish power of attorney, which of course would allow some other person to transact on your behalf, maybe place trades, maybe withdraw money, whatever the case may be. That type of power of attorney on an institutional basis becomes null and void in the event that you are mentally incapacitated or physically unable to make these sorts of financial decisions for yourself. And that's where a durable power of attorney comes in, because it allows that person to do just that in the event that you are mentally incapacitated or physically unable to transact on your behalf, do things like filing taxes, paying bills, all of these important financial matters that need to be taken care of, regardless of whether or not you're able to do those things. DPOA is something that there are actually a couple different types. There's the type that becomes effective in the event that you're unable to make these decisions, become mentally incapacitated, etc. Or there's also the type that's just effective immediately. And these can be nice if you have found yourself in a situation where you have a terminal illness or you have a risky surgery coming up. You might want to get that established ahead of time just because you never know. Okay, second item to consider is advanced medical directives. Now, these are going to be important for you to establish what kind of medical care you're okay with receiving in the event that you can't physically express what you would want. Yes, it allows you to either designate what kind of care you approve or disapprove of, or you can establish a single person to make these decisions on your behalf. And we know that if you do not have advanced medical directives established ahead of time, that medical care providers are actually required to prolong your life, even if it's by artificial means. And not knowing how long they would be doing this for you, we understand here in America how expensive that can become. So very important that you have these decisions made ahead of time, or that you've had a conversation with the person that you've designated to make the decisions, so that all of that is figured out ahead of time. Of course, we don't want to put that type of burden on our loved ones or on our family when it's already difficult enough on everybody. Okay, now number 3 is your will. This is often the first thing that people think of, right, when they think about their estate planning. And if you're unfamiliar with a will, what it does is it designates how you would like your property to be dispersed upon your passing. Now, important to note about the will, it does not avoid your estate going through probate, but it does do a few very important things for you, such as, number 1, it does help you to establish who your executor will be. Now, your executor is the person who is there to legally take care of whatever you've designated in your will, all of the things that you want to make happen, making sure that assets get dispersed in the manner that you have determined ahead of time, as well as, number 2, to establish guardianship. So if you have children that you are taking care of, that you're responsible for, younger than the age of 18, if you are to pass away, we want to establish someone that you trust to take care of them. And like I always tell my clients, if you don't have a will, if you don't have an estate plan, the state has one for you. So when it comes to legal guardianship, if you have not established who you'd like that person to be, well, guess what? The state will figure it out for you. And depending on your family dynamic, that may or may not actually be something that you want. So very important to consider that when looking at your will and your estate planning generally. Now, number 4 is a letter of instruction. So this is actually a non-legal private document that you establish. It's sometimes called a testamentary letter, sometimes called a side letter, but it is something that you are laying out specifically line by line. Here are the things that I want to make happen after I pass. And these can be things that you ask various heirs to accomplish for you, or specifically just your executor. Things like burial wishes, for example, very important to establish that ahead of time. But like I said, since it is a non-legal document, it's actually not one that they have to follow, but it is private, so you can lay out things that are a little bit more sentimental and important to express to your family in that letter of instruction. Number 5 is going to be your living trust, also known as a revocable trust, inter vivos trust. And because it is revocable, it allows you to actually make changes to the terms of the trust while you're alive. And what's nice about the trust is the goal, of course, is you're creating a separate entity in order to own your property, such as your investments or your real estate. It generally doesn't need to encompass things like your IRAs because those already pass outside of probate. But yes, the living trust does ultimately make matters much more private in that you're avoiding probate. And it is something that, like I said, you can make changes to, kind of like an open box where you've got the terms all laid out in there and you can make changes to them and get your hands all up in it anytime you need to during your life. Unlike an irrevocable trust, by contrast, that's more like a closed box. The terms are already determined. You can't make any changes to it. So revocable trust, something to consider. And just like all of the other 5 documents, I do recommend that you speak with an estate planning attorney in your state who's familiar with the local estate laws, so that they can make specific recommendations to you for what to do, what's appropriate, what's not. And if you're here in Denver with us, we do have local contacts that we are happy to connect you with. So hopefully this has been helpful. Let us know what other questions that you have about your estate planning needs, and we're happy to keep the conversation going. Thank you.